BuCor Chief Nicanor Faeldon nadiin sa pagdinig ng Senado. Si Eagle News reporter Mean Corbera.
Nadiin pa sa pagdinig ng Senado si Bureau of Corrections Chief Nicanor Faeldon kaugnay ng pagpapalaya sa mga nakatulan sa heinous crime sa ilalim ng Good Conduct Time Allowance Law. Sa pagdinig ng Senado, inamin ni Justice Secretary Senado na wala itong nilagdaang anumang rekomendasyon para sa pagpapalaya sa mga bilanggo sa BuCor, kabilang na si dating Kalawan Mayor Antonio Sanchez. Sinabi kasi ni Senate Minority Leader Franklin Drilon na batay sa itinatakda ng Republic Act 10592 o GCTA law, dapat may approval ng Secretary of Justice ang anumang request para sa pagpapalaya ng mga bilanggo, kabilang na ang kay Sanchez at ang mga convicted drug lords na pawang mga Chinese nationals. Itinanggi ni Faeldon na siya ang pumirma sa release order, katunayang pinusyon niya pa raw yung nakatakdang pagpapalaya kay Sanchez. Pero nang ipakita ni Senator Tina kung ang specimen signature, inamin nito na siya ang nakalagda sa release order. Pero depensa ni Faeldon, hindi raw ito release order kundi isa lamang memorandum para masimulan ang pagpuproseso kung karapat-dapat ba siyang mapalaya. Kinumpirma naman ni Faeldon na nakalaya sa pamamagitan ng batas ang mga nang-rape at pumatay sa magkakapatid na show sa Cebu. Sa datos na hawak ng Senado, umaabot sa 1,914 na convicted criminals ang napalaya ng walang approval ng DOJ, kung saan 194 dito ay mga convicted rapists. Narito ang bahagi ng pagdinig ng Senado.
We noticed that you included every day of detention. Is that correct?
That is how they computed it, sir. I can only compute during the time I am the Director General, Your Honor.
Under the law, those charged with heinous crimes are not entitled to credit of their preventive imprisonment. Is that correct?
I agree with you, Your
Yes,
Honor.
that's the law. But in the case of Sanchez, you credited him with the 6 years in order to arrive at 49 years. Is that correct?
The previous Director Generals during those years were the ones who credited that because
Sorry?
those computations were done during the years. So I have just assumed few months, sir. So I cannot grant GCTA during the times I wasn't.
Dumipesa naman sa pagdinig si Faeldon at iginit na napalaya ang mga bilanggo batay sa kanilang magandang asal at hindi paglabas sa mga prison rules. Iginit ni Faeldon na wala namang silang binago sa batas mula nang ilabas ang implementing rules and regulations noong 2014. Sa ilaliman niya ng IRR kasama ang lahat ng bilanggo sa maaaring makinabang sa GCTA dahilan kaya lahat ng convict ay napasama sa mga nireview ng BuCor. Mula sa Senado para sa Eagle News, Mean Corbera, IM 135.
Mean?
Yes, yes.
Naliwanag ba talaga doon sa IRR kung tinanggal yung salitang heinous crime mula doon sa original na batas?
Ang sinabi ni Secretary Guevara kanina, Jen, doon sa kaso ng heinous crime, nagkakaroon ng kalituhan dahil hindi raw malinaw doon sa IRR. Doon sa batas malinaw, pero doon sa implementing rules and regulations na binalangkas, hindi malinaw kung yung mga nasa heinous crime ay mapapasama at makikinabang. Isang magandang pagkakataon daw yung paglutang ng kaso ni Sanchez para revisahin at busisiin muli ang isang saad ng IRR ng batas.
Kailan ba nagsimula yung pagpapatupad nila nung mga nakinabang sa GCTA, Meng?
Naging batas siya na nagdaan noong 2013 pero dahil bumalangkas pa ng IRR ay naipatupad ito noong 2014. Batay nga sa datos na hawak ng Senado, mula noong 2014, umabot sa 1,914 ang napalaya, kung saan 194 dyan mga convicted rapists at napasama din sa listahan yung mga datos.
2014 pero nagkaroon ng pag-question dyan sa Supreme Court, di ba?
Dahil dun sa kaso ng isang Taiwanese national na kinukonsult kanina ni Senator Pinacon, ang sabi niya bakit siya napasama, yung kaso niya karumal-dumal at ang sabi nga daw, ang Pangulo pa mismo ang nagigit na yung mga drug lords hindi dapat pabibigyan ng o napapalaya. Pero sabi ng BuCor kanina ay umapila ito sa Supreme Court At nagkaroon nga ng ruling na mula nung maging batas ito, dapat retroactive na ibig sabihin ipapatupad yung batas.
Tama ba mula nung magpasya yung Supreme Court hanggang ngayon, parang mga 200 na mahigit ang napalaya?
1,914 then to be exact.
Mula nung 2014.
2014. Oo, noong 2014. Pero ang sabi ni Faeldon, meron pa silang nire-review, baka umabot ng 11,000. Ayun din yung inanunsyo ni Secretary Guevara prior dito sa pagdinig sa Senado.
Pero ang Estado ngayon, pinahinto lahat ito.
Oo, pinatigil munang lahat yan habang nire-review dahil may binuong joint committee ang DOJ at ang DILG habang hindi pa natatapos yung review ay stop muna yung pag-grant ditong pagpapalaya. Kasama dyan kinumpirma ng BuCor o ni Secretary Lacson, ni Senator Lacson na yung Chinese nationals na sinasabing napalaya, 5 yun, ay nasa kustodiya pa nila, hindi pa nakakalabas. Dahil habang pinoproseso sana yung kanilang pagpapadeport sa kanilang bansa, na-discover nga itong anomalya dito sa GCPS.
Pagka ganun ba, pwedeng bawiin yan? Kasi hindi pa naman pala nakakalabas ng bansa, di ba? Nabanggit ba sa hearing yon?
Meron daw chance na maibalik sila sa may laguan. Yan daw yung inaalam ngayon dito sa ginagawang review ng DOJ at ng DILG.
Nasa immigration, nakalaya o nasa immigration pero binabantayan lang ng immigration? Nasa kulungan ba ng immigration sila?
Nakalabas na actual sila ng BuCor sa New Bilibid. Nakalabas na sila, i-turn over sila sa immigration. Habang ipinoproseso ng immigration yung kanilang papeles, yung kanilang deportation papers, bumulaga nga itong story na to. Kaya natigil din yung kanilang paglabas ng Pilipinas.
Kasi merong sariling kulungan ng immigration dyan sa Taguig eh. Sila ba nakakulong pa hanggang ngayon doon?
Nasa kulungan pa daw siya.
Ayun, buti naman pala, no? Ngayon, sa mga sandaling ito, Meg, sino nagtatanong at sino ang tinatanong?
Si Senate President Vicente Soto yung nagtatanong. Ang tinatanong pa rin ay itong si Yusek Nicanor Faeldon. So, sa mga rules na ipinatupad, kaya na dyan bago pala magtanong si Soto. Tinanong ni Senator Riza Hontiveros si Faeldon. Ang sabi niya ay, Secretary, kung kailan siya magre-resign. Wala ka bang balak na mag-resign? Ngayong nilalagay sa balag ng alanganin yung pwesto mo. Sabi ni Faeldon, naniniwala daw siya na ginagawa niya mabuti yung kanyang trabaho at wala daw siyang balak mag-resign. Ipinaubayan niya daw sa Pangulo yung desisyon kung tatanggalin siya sa pwesto.
Sa tingin ko, mahalaga yung tanong na Senate President Vicente Soto. Pwede bang mapakinggan natin yung real time? Kasi ito pinapakita namin sa video ngayon. Ito yung mga nauna eh. Ito yung kanina pa eh.
Narito yung bahagi ng pagdinig ngayon ng Senado.
It did not exclude any type of offense they committed. It was granted to all PDFs.
Sa kasalukuyan ngayon po, gano'ng kadami kaya pa doon yung mga elderly at saka yung may mga sakit na hindi nagka-qualify dito sa GCTA sa computation ninyo?
We will submit your everyone is qualified for GCPA, Your Honor, but whether or not their time, their sentence was already served as the basis for their release is another thing, sir. So we will submit the elderly because there are some newly convicted, 78 years old. So, and their sentence is reclusion perpetua. So inaabot sila talaga ng katanda na after 20 years. So may mga matatanda doon nakapapasok pa lang sa kulungan, Your Honor.
Alright.
So they still cannot be released, even they are old, Your Honor.
Before the advent of 10592, it was the revised penal code that provided for good conduct, good behavior, and all this. Okay, so what happens, Secretary Guevara, if we
time credits, then we revert. to
Refer
what
to
is
the revised
what
penal
is being
code.
provided in the revised penal code.
Right.
With the permission of the Senate President,
Yes.
kung bibigyan po natin ng advice yung Chong family, given the circumstances na release na yung tatlo, and then mukhang helpless ang situation because necessarily they will have to go to the Supreme Court and determine if there's grave abuse of discretion in the release of the 3 convicts, applying Rule 65 of course. So yun na lang ang pwede lang course of action to take. Go to the Supreme Court and question the release of Asnar, Anyo, and Balansag.
That is one of the possible remedies that the family.
Then what are the other possible remedies aside from going to the Supreme Court? No, si Senate President is from Cebu. I also came from Cebu. I was assigned there and I more or less I know the family of the Jong sisters. So I'm interested to find out anong remedyo pwede nilang gawin na mabuti yung kay Antonio Sanchez na preempt. And what has been clearly established so far in this inquiry is that a release order has been signed. And if not for the public uproar, wala na si Sanchez, nakauwi na ng Kalawan. So, what are the other possible remedies aside from going to the Supreme Court?
I do not think that ordinarily, if the person has not yet been released, a petition for declaratory relief may be filed with the regional trial court. Other than that, since it's a fait accompli already, Mr. Senator, it's really more of a petition for certiorari and prohibition under Rule 65 of the Rules of Court.
I agree po, but of course they can invoke Department Order 953 because sa paragraph 2 nakalagay doon, basta reclusion perpetua. Remember, it doesn't even mention heinous crimes. Nakalagay lang, basta reclusion perpetua, dapat yon upon the prior approval of the Secretary of Justice. And most of these cases, if not all of these cases, kaya nga reclusion perpetua, heinous crimes. So it follows that all 816 or 1,914 na na-release pwedeng interpret na merong grave abuse of discretion because it is beyond their discretion to release those convicts without prior approval ng Secretary of Justice.
Precisely, the remedy is one for certiorari and prohibition on the ground of excess of jurisdiction or lack of jurisdiction. So, if the same was done without the prior approval of the Secretary of Justice as mandated by that department order, then it can be viewed as lack of jurisdiction, there being no prior approval, or excess of jurisdiction for the reason that they exceeded the bounds of their authority in making a release without the prior approval of the Secretary of Justice. Either way, the net effect would be to nullify.
Mr. Chairman, with the permission of the Senate President, just to interject,
With the permission of the Senate President, of course.
to follow your line because it will be difficult for me to come back. I'm number 11. But this is the point that I'd also like to make to support the Senate President's point on this, Mr. Secretary. Similar to a quo warranto case. We're all familiar with quo warranto cases. This is like a quo warranto case. Nagkamali yung recommendation, nagkamali yung dokumento, sinubmit, inappoint, and therefore, mali yung proseso at natanggal. Similar to a quo warranto case, can't we not intervene this way? That the process, as you see, is very flawed. They failed miserably in the conditions for pardon, and they also failed in the process, as other people were signing on behalf of the Undersecretary Faeldon, on maybe and all the others in the previous years. Can't we not also invoke similar to quo warranto proceedings and therefore recall these prisoners? Because, Mr. Secretary, this is tainting our administration's fight against criminality. This is the cornerstone of the president. So just that interjection, Mr. Senate President, I hope you don't mind, because that's the point that I raised also with Senator Dulon. But isn't this similar to a co-warranto case?
Senator, if I may just make a brief reaction to your statement. It is analogous or similar to co-warranto only in the sense that certain people, PDLs, who committed heinous crimes are not eligible in the first place to be credited with any time allowances. Alright, so to that extent, it is similar to quo warranto, but the proper remedy is not quo warranto itself, because we're not talking about a public office here. So, but the idea is similar. Not eligible to begin with. Alright, but the remedy is not quo warranto, but application for certiorari and or prohibition.
Yes, the point of the majority leader is, he means it's analogous.
Yes.
As analogous.
Just,
So,
may
with
I
permission
ask-
of the chairman,
Just one point. I invite the Secretary of Justice to examine the case of People versus Tan. This was decided on February 25, 1967, where the facts are similar to this. In that case, Tan, the defendant, the accused, was released by provincial warden on good conduct time allowance. There was an error found by the court. The fiscal moved to rearrest the accused. The court allowed the rearrest. So in this particular case, the rearrest of those 1,914, if found that they were in violation, that the release was in violation of the law and the rules, they can be rearrested on the authority of People versus Tan. May I request the Secretary of Justice to review this case? It's GR number L21805, dated February 25, 1967.
We shall take a look at that jurisprudential ruling.
I think with jurisprudence there. Oh, anyway, so just two more very small questions, but very important.
I joined the minority control leader in taking a look at that case, because I think I've always maintained that you can rearrest based on an act that was based on false pretenses or false law or false implementation or interpretation of the law. Go ahead, please.
All right. Now, in the case of the one in Davao, Chief Superintendent Faustino, you were not able to tell us, to tell Senator Lacson, what was the loyalty that that particular guy did to be released. When he was released on special time allowance loyalty. Ano yung ginawa niya?
Because of to keep credit during the time of Yolanda. Because at that time, he was confined at Leyte Regional Prison. And following the case of Yolanda, he was also credited of another 2 feet for the fires that caused the destruction of Leyte Regional Prison.
So, hindi tumakas?
Yes, sir.
Bumalik. Okay.
That is provided for in the law. Hindi siya tumakas.
Yes, sir. That's a new provision in 10592, sir.
One final question. This has been bugging many people that have gotten in touch with me. To the Bureau of Corrections, and I hope the Secretary Guevara will pay close attention. Who is Roberto Traya?
He is an employee of the Bureau assigned at the documents section, Your Honor.
He is the Assistant Chief Document Section of the Bureau of Corrections, correct?
Yes, Your Honor.
All right. He was killed
Yes, Your Honor.
August 27.
Assassinated.
Yes,
Assassinated. Yes. Right?
Yes, Your Honor.
Very near the Bureau of Corrections or NDP, right?
At the poblasyon.
Gumugulo ang kaisipan ng marami because if you will look at the matrix ng procedures ninyo, document section, doon nagsimula itong mga release orders. Merong co-compute yung GCTA, tapos drafts ng memo, ida-draft nila yung memo, papadala sa Director for Security and Operation, papadala sa Office of the Director General, and then sa Legal Officer, re-review yung draft memo, then the Director General signs the memo. If the Director General is not available, a designated duty general are authorized. Then it goes back to the Office of the Director General. It is scanned for the record. It goes back to the document section, and the record section na kung saan nagtatrabaho itong si Roberto Traya na inassassinate. Sino pumatay dito kaya? Ano bang tingin ninyo nangyari dito sa tauhan ninyo? O sino nagpapatay? Meron bang na-displace ito sa corrections or sa mga preso? Or
Based on the initial investigation, sir, 3 years ago, he was ambushed in Leyte because he used to be assigned in Leyte. Because he's also in connivance with the PDL that was recently also napatay na rin. So, that is, dito yung lumalabas na yung nagtangka sa buhay niya sa Leyte, mukhang yun pa rin. And then the PDL na nahuli na ka-text niya ay namatay na rin, pinatay din. The same day. But yung PDL na yan ay nandun sa ibang lugar, sa Leyte. So, lumalabas na sa initial investigation, dalawa silang pinatay. But, nung araw na yun, the reports is ito ay inabos na rin ng 3 years. Yung kahit lipat dito sa Manila, sir. But, I cannot divulge further the investigation because it's still ongoing, but that is what the PNP and our internal investigation is leading to you.
because of the recent controversies surrounding the Bureau of Corrections, I think it's just but proper, Secretary Ibarra, for the NBI to investigate thoroughly and get to the bottom of this ng malaliman siguro kapag yung tao assistant chief ng document section involved dito sa mga nire-release, ma-assassinate 7 days after a so-called controversial release is done and what we just not consummated. So perhaps we would await a report from you thereafter. All right? Thank you. Mr. Chairman, I will terminate at this point.
Just a follow-up, just one question. Who appointed this guy, Traya?
I will find out, sir, but it is here Plantilla.
I understand he was transferred by Secretary De Lima to Leyte. Is that correct?
He is from Leyte and transferred 3 years ago to NBPO.
Was that because of drug relationships?
He was
Or connivance or whatever? Huh?
Yes, sir. He was ambushed in Leyte 3 years ago. I still have to look for the motive of the ambush, Your Honor, but the initial investigation is that he is connected to some PDL inside Leyte.
Connected to the?
To some prisoners, PDL, persons deprived of liberty.
That is in connection with the killing by of the mayor of Albuera, Espinosa, and I understand from the General Elizar that they're investigating that angle because somehow he was involved in that in some drug operation. That's why I'm asking who appointed him and who transferred him back.
For a long time, he was ambushed. After he was not appointed, and then 3 years ago he was transferred to Alright, I mean, pretty sure the NBI will look into this.